So it's now 2025, and last year for M.A.J. law was a fantastic year. We won more drink and drug driving cases last year than we have any other previous year. And bearing in mind, we've been doing this for almost 15 years now. And I guess the reason for the success and the number of cases that we won was that the approach that we've been taking with drink and drug driving cases is slightly different. We've been focusing on the more technical arguments as well, but also a lot's changed with the police and the prosecution. And it seems to me that they simply aren't as good at prosecuting these kinds of cases as they used to be. So hopefully 2025 is as good a year, if not better, for case victories as what we saw last year. Now, the purpose of this video is to really bring you up to speed with the latest developments in drug driving cases and talk more about how we dealt with, handled and successfully defended some of the drug driving cases that we dealt with last year. And that's hopefully going to give you an idea as to how you might be able to defend a case that you're involved in, if it is a drug driving case that you've been charged with, or perhaps you're still under investigation. Because even where a person is under investigation or even charged and sent to court, that does not mean to say that you are going to be convicted of the offence of drug driving, even where you're over the legal limit. There are a number of different ways that you can defend and challenge these kind of cases. Now, there's generally three ways that we successfully defend drug driving cases. And the advice in this video is going to relate to a standard, or let's call it an ordinary drug driving case. And by ordinary, I mean you were pulled over by the police, you failed a swab test at the roadside, you were taken to the police station where you provided a sample of blood. And 90%, if not more, of all drug driving cases will begin in that way. If your case is different, if you weren't pulled over, if you didn't fail a swab test, if you were taken to the hospital, then there may be a number of additional ways or other ways that you can challenge that drug driving case. And so if your case has any of those features, then feel free to get in touch, because there's going to be a lot to talk about, a number of different ways that you might be able to defend that case. So let's deal with a standard drug driving offence. Now, the first thing to think about in a drug driving case, and the first aspect of the case that we might want to challenge, is procedure. And when we talk about procedure, it really relates to what happened in the blood test room when a sample of blood was taken from you. And the reason why that's so important is because it's a very strict and very well prescribed procedure. It has to be carried out in a certain way, in line with what's called the M.J. document. Now, if you've read any of our blogs, our case studies, and even watched some of our previous videos, we talk a lot about the M.J. procedures in these kind of cases. And that's because it's the first thing that I'd always want to check. If the procedure was not carried out correctly, it doesn't matter how far over the legal limit you are, it doesn't matter how serious the drug driving case is, by law you can't be convicted if certain parts of the M.J. procedure aren't carried out correctly. And that's why it always makes sense to check, because what we tend to find, again, just from challenging these cases every single day, is the police don't always give people the right information. We know that from time to time they cut corners. They may want to get the sample of blood from you as quickly as possible because they want to get the highest reading. And of course, they know the best way to get the highest blood results is to quickly push you through that process and get that sample from you quickly, because of course drug levels will drop and reduce over time. And if in doing so, they've skipped certain parts of that procedure and haven't gone through the documentation in the right way, then the police can't use that blood sample in evidence against you. Now, you might think, well, how do we prove that the procedure was not carried out correctly? Well, thankfully, and one, I guess, good thing about being a defendant in a drug driving case, or really in any criminal case, is that you don't have to do the proving. If the prosecution charge you with an offence and send your case to court, then they carry the responsibility and the burden of proving that you are guilty of that offence. And of course, that's not just about proving that you're over the legal limit. Most people are in drug driving cases because we know that the legal limit is, for most drugs, absolute zero tolerance. So it's not just about proving that you're over. That's the easy part for the CPS. It's proving that every other aspect of that case was carried out correctly, and that includes the procedure. So in fact, it's for the police and the CPS to prove, with the service of evidence, that the procedure and the process when taking that sample was carried out in the right way. Now, think back to when you were in the blood test room. It's not as simple as just giving your consent. So you might at this stage think, well, I gave my consent, and that must mean that I've given my permission, and therefore they can use the blood sample. Well, consent is the easy part for the police, because most people know that whenever you give a sample of blood in any context, you normally have to give your consent. And the police know that as well, and it's the nurse in any case that would ask for your permission to take that sample. What we're really talking about and what's important to drill into in a drug driving case is the paperwork, and not so much what the nurse told you, but what the officer was meant to tell you. And so what they are supposed to do, and this is really just a quick summary, feel free to get in contact if you want to talk in more detail about this, but what they are supposed to do is go through roughly a 25-page booklet in the blood test room with you. It's called an MGDDB document. So it stands for the Manual Guidance for Drug Drive Pro Forma B. And that contains a long list of questions that the police have to ask you in relation to the blood test. And these are separate to the questions that you're asked at the front desk. So let's not get confused between the two. But it's a long list of questions they have to ask you in relation to the blood test. But they've also got to go on and explain to you that you don't have to give a sample of blood if you don't want to, and what the consequences or what the outcome will be if you didn't give a sample of blood. Now, you might be thinking, well, at no point did the police explain that I didn't have to give a sample of blood. I was told, or I was made to believe, that I had no choice, that I had no option, that I had to provide a sample of blood. Sometimes the police will go one step further, which of course is completely unlawful, and they might try and pressure you, coerce you, persuade you into giving a sample, make it sound worse if you don't give a sample. So they might say, for example, if you don't give a sample, you're going to be worse off. It's an instant ban. You're going to be kept in the police station for longer. You may be sent to court a lot sooner or sent to court straight away. And they do like this phrase, instant ban. We often hear the police using this phrase, instant ban. Remember that in drug driving cases, in drink driving cases, in failed to provide cases, there's really no such thing as an instant ban. Can't happen with this type of area of law. So always be very careful about what the police will say to a person or may have said to you in that blood test room. I know it can be difficult to remember word for word exactly what went on, but think back and try and remember what was said and what they may not have gone through. Now, the best way to try and gauge whether the police have gone through that procedure with you, because you're not going to remember word for word what happened, is really timings. Now, the MGDDB document, even for a very experienced police officer, it could take 20 minutes, but in most cases it's going to take a lot longer. I've dealt with cases in the past where an officer may well have gone through the paperwork and the procedure correctly, and that's taken him probably about an hour to go through the paperwork, the documentation, ask all the right questions, tick all the right boxes, and of course write down your responses to each of those questions as well, which he has to do on the MGDDB document. So if you're in that room for 10 minutes or 15 minutes, and that involves just taking a sample of blood and giving your consent, and that's a really strong indication, even this early on in a case, that they haven't gone through the procedure properly with you. Now, what we might want to do, if that's obvious or apparent in your case, or if your instructions to me, if I'm defending you, are very clear that at no point have the police gone through that procedure with me, then even before a first court date, we're perfectly entitled to write to the police and the prosecution and formally invite them to withdraw the case against you. If they go ahead and check their paperwork and their evidence as a result of or a reaction to that request that we've made, and they realise that procedures were not carried out correctly, then they have no real choice. In these circumstances, remember, there's no exception to the procedure. It has to be carried out in a certain way, and you may find that the case is even dropped prior to a first court date. There's also a few other things to look at that I won't cover in this video. We'll think about how the sample might have been taken, how many attempts were made to take the blood, because again, there's certain limits on how many attempts can be made. If there were multiple attempts, was any amount of blood collected on those previous so-called failed attempts, and if so, how much? And then was the sample shaken for the correct period of time? Did you notice the nurse adding the correct sodium fluoride preservative and anticoagulant to the blood? Was it labelled correctly, stored in the right way? And this may not be things that you would know of or be able to check right now, but this is what we might go on and check and look at in relation to the procedure as the case continues. And the prosecution normally have to provide evidence in relation to all these different things and all these different questions that we can ask them. So procedure in a drug driving case is hugely important, and that's how we win an awful lot of the cases that we challenge. And the second thing to look at, and this may come at a much later stage in the case, but even now it's really important to consider, is the forensic evidence. And that's the evidence that comes back from the lab that analysed your sample for the police. The police won't give you much information about that process at the very early stages because they don't have to. But if they do charge you with the offence, at some stage in this case, you'll receive what's called an SFR1. It's a Streamlined Forensic Report number 1. And that's a very short form, very limited if we could even call it an expert report, it's probably a summary of expert evidence that won't really tell us much about the way the sample was analysed or who by, possibly even what lab, what method of analysis was used, was it an approved and recognised method of testing. It just tells us the results. Now, one thing to be aware of when we look at these SFR1 documents, and I'm completely convinced that whoever designed these SFR documents and first put them together were told that they had to make them look as official as possible. By that I mean they look very serious. And of course they are serious, we are talking about a criminal case, but they're really designed to make you think you're guilty. It's important to know and to understand that the SFR1 document, remember this short form expert report that you'll see at some stage in your drug driving case, in my view is not even worth the paper it's printed on, because the moment I formally reject the SFR1, so I notify the court and the prosecution that we're not accepting, say, the results of the blood test or any other part of the forensic methodology in relation to the blood sample, the moment I reject it, that SFR1 document can't be used in evidence against you. And the only way the prosecution can then prove that you are over the legal limit, because they can't now use the SFR1 and they're going to need some kind of forensic evidence to present to the court to say that Jack had 5.6 micrograms of THC in his system, it means going back to the lab and relying on a secondary expert report. It's an SFR2. Now, at the point at which you reject the SFR1, and indeed at the point in which you're charged with the offence of drug driving, the SFR2 document won't exist. It's only produced as a result of me rejecting the SFR1 document. And the purpose of the SFR2 is it's designed to, or it's supposed to, address any issues that the defence may raise with the initial short form expert report, the SFR1. So let's, as an example, if I reject the SFR1 because I'm concerned over the length of time your sample was held in police custody before being sent to the lab, if you've not been charged for 4 or 5 months following your release from police custody, then any delay is normally on the part of the police, and that delay might relate to your sample being sent to a laboratory. Now, we know from experience and past cases that the police don't really have suitable storage conditions for long-term storage of evidential forensic samples, because we're not talking about the police having access to specialist, secure, temperature-controlled forensic fridges in the same way that a police laboratory may have, or an outsourced laboratory might have. It's a kitchen fridge. Now, clearly it's not appropriate to store an evidential sample in a kitchen fridge for 3 or 4 months before sending that sample off to the lab for testing. So we might reject the SFR1 for that reason. Now, the only way the prosecution can then prove that you had X amount of THC or any other drug for that matter in your system is to go back to the lab that first analysed that sample, however many weeks or months ago that may have been, and instruct that lab to produce a secondary, more detailed expert report by one of their forensic scientists. And bearing in mind that forensic scientist may have had no involvement in your case whatsoever. This could be the first time that they hear your name, look at the evidence in your case, and look at the scientific evidence in your case as well. A lot of the testing work that's carried out by laboratories across the country in drug driving cases, I suppose as a cost-cutting measure, is carried out by agency staff. It may be people with less than a year's experience. They may have no qualifications whatsoever in forensic science, but these are the people that are analysing blood samples. So we can reject the SFR1 for that reason, and they've got to produce an SFR2. Now, going back to the number of cases that we won last year, drug driving cases, the vast majority, probably upwards of 60 to 70% of the cases that we won because the prosecution didn't provide the SFR2 document in time. And this is now why it's actually become a really effective way of challenging a drug driving case. And I suppose in part it's to do with delays on the part of the prosecution service. We know there's a massive backlog of criminal cases currently. They're overworked, they're underfunded, just like any government-funded agency or organisation is, and they do struggle to keep on top of the workload. We've also seen, particularly last year and no doubt into this year as well, industrial action, prosecution complaining about the workload, working conditions as well, pay. And so that's also had an impact on the way the CPS deal with what they might consider to be a low-level, low-priority motoring offence. Because although this may be very serious for you, and I don't seek to minimise the seriousness of a drug driving case, because of course it's serious and the consequences can be far-reaching, at least for the Crown Prosecution Service, who all day, every day are dealing with the most serious crimes across the country, a driving offence is always going to be less serious and therefore a lower priority than something that's more serious, where somebody may go to prison, where somebody's been injured, where a violent crime has been committed, etc. And that can only be a good thing from our point of view, because that means things get missed, overlooked. It may be a less senior prosecutor that's dealing with your case day to day, that is less familiar with how the forensic evidence works in drug driving cases. So whenever you challenge a drug driving case, please don't forget about the forensic evidence. There's lots of solicitors, and not to criticise anybody that deals with these cases or defends them, but there's lots of solicitors that I see handling drug driving cases in and out of court that focus far too much on the legislative framework, the procedure. What does the Road Traffic Act say? What does the law say? The problem there is the prosecution know it all too well, because the CPS are lawyers as much as we are too. Whereas what they forget to focus on, or don't focus on, is the science. And generally, in my experience, the CPS aren't as clued up on the forensic science side of a drug driving case because of how technical and how complicated it can be. And that's the best way to outsmart and outmaneuver the prosecution. And remember this, over half of all of the evidence against you in a drug driving case is going to be scientific in nature. It's not just about the law and procedure and what went on at the police station. Yes, that's important, but it's also about the storage, the handling, the labelling, the preservation of the blood sample, what lab it was sent to, the method of analysis that was carried out. They're meant to use a very technical method of analysis in drug driving cases, what's called liquid chromatography, tandem mass spectrometry. And we know that the labs instructed by police stations don't have the best reputation when analysing drug driving cases. So let's not forget about the forensic evidence in a case like this, and that again can be a really common way of avoiding convictions if you are charged with a drug driving offence. And the final thing to think about really quickly is just prosecution disclosure, and this sort of blends into what I've just told you about delays on the part of the prosecution. Of course, they have to produce forensic evidence within a certain amount of time, and on, say, the first court date, if we plead not guilty, the court will set additional directions. They may tell the prosecution to serve evidence within a certain amount of time. It could be 28 days, could be 3 weeks, could be 6 weeks, depending on the kind of evidence the CPS need to provide in a case like yours. They may get a little bit longer for, say, forensic evidence, and a little bit less time to serve things like witness statements, because they'll generally already be in possession of that kind of evidence. It's a little bit easier to produce and come up with, and less time consuming than forensic material. But when the prosecution invariably fail to comply with court directions, as they do in all of the cases now that we deal with, very rarely, in fact ever, will the CPS provide additional disclosure within 28 days, then we can make applications to exclude the evidence against you. And this is another reason why we defend cases in this way. We might encourage a person to defend the case, even if they haven't got a so-called recognised defence, because we know that the CPS are going to have some difficulty in producing further evidence, in complying with court directions as well, and providing that evidence when the court tells them to. And again, it's the backlog, it's delays, it's staffing shortages, and it just feels to me as though the CPS just don't have the manpower, the resources, the energy levels to prosecute these kind of cases properly. And again, that's no criticism to the CPS, because they can only work within a certain budget. They've only got a limited number of people that work within the Crown Prosecution Service and that can provide evidence, review evidence, and work out what needs to be served in any given criminal case. But if they don't comply with those court directions, as is often the case with these kind of offences, they can't keep up and the evidence isn't served in time, then we can normally make applications to exclude the evidence against you, whether that's Section 78, where we're arguing that the admission of such evidence would have an adverse effect on the fairness of the proceedings against you. If it's forensic evidence, like we've just spoken about, it could be Part 19 of the Criminal Procedure Rules to exclude the evidence. It might be under the Criminal Procedure and Investigations Act. It could be using the Magistrates Court Disclosure Review or the Attorney General's Guidelines on Disclosure. There's all these different mechanisms that we can try and rely on to exclude evidence when the prosecution don't do their job properly and they don't provide the evidence in time. So just to recap, first thing to consider in any drug driving case is procedure, procedure, procedure. Because if that procedure is not carried out correctly, prosecution may not be able to use the blood sample. And if we take the blood sample out of the equation in a drug driving case, then there's no evidence to prove that you are over the limit, and therefore you can't be convicted of drug driving. The second thing to think about is the forensic evidence. We're going to be doing more videos on this over the next few weeks and months, because there's so much to think about with drug driving cases, all the forensic evidence, there's so much to talk about and so much information that I'd love to be able to share with you insights into what we've seen, stories that I can tell you about drug driving cases that we've dealt with previously. But forensic evidence is massive in drug driving cases, and we'd be silly, we'd be crazy not to consider challenging a drug driving case on forensic evidence, because there's so much that can go wrong for the CPS throughout the course of a drug driving case. And then just finally, and this does tie into this, is prosecution disclosure in general. So that's the ability for the prosecution to provide evidence when the court tells them to, and they often don't do that. When the court tells them to, and we know from experience that the prosecution don't do a very good job at keeping up, providing evidence in time, complying with court directions, and there's different ways then that we can see to exclude the evidence because the CPS haven't complied and haven't done their job properly. And again, just going back to what I spoke about at the beginning of the video, those are the issues that we might look at in a standard drug driving case. If your case is different for whatever reason, there may be a number of other defence arguments that apply as well. And there's also one or two other clever ways that we might be able to avoid a conviction in a drug driving case as well. As always, the best thing to do if you find yourself charged or suspected of committing a drug driving offence is just to make contact with solicitors, whether it's us or any other firm. Most solicitors will give free initial advice over the phone. You'll find our contact details in the description of this video and on our website. You can even request a call back as well. Get some advice in relation to your case, your circumstances, and then we can really get stuck into the different issues and potential defence arguments that might apply in your case in particular, because every drug driving case is different. Everyone's circumstances are different as well. As a final point, something else that I just wanted to mention before we conclude the video, something that we've been looking at more recently as well that can work very, very well, and especially at the early stages of a drug driving case, is the possibility for the police to issue a simple caution. Now, simple cautions are not typically something that is routinely offered in drug driving cases, but there's nothing in law that prevents the police from issuing a simple caution in a drug driving case, because there are only three criteria that we need to be able to satisfy, three boxes that we need to be able to tick in order for the police to issue a simple caution in a drug driving case. First of all, you have to be an adult offender. So if you're under the age of 18, then they can't issue a simple caution, but actually the consequences may not be as severe if you are under the age of 18 anyway. So you have to be an adult offender. Second of all, you must have no relevant previous convictions for drink or drug driving. And it does help if you have no previous convictions at all. Now, it doesn't rule out the possibility of a caution, even if you do have a previous conviction, but that's the first thing the police are going to look at. So if you've got no previous convictions, that improves the chance that the police will allow a simple caution to be issued. And thirdly, it has to be a summary only offence. And by summary only, it means that it can only be dealt with in the magistrate's court. We'd be pleased to hear that drug driving as an offence is a summary only offence, which means it can only be dealt with in the magistrate's court. So I see no harm done, providing it's the right time, if it's early enough in the case, writing to the police, setting out those circumstances, and seeing if we can get an alternative out-of-court disposal, such as a simple caution instead. And look, worst case scenario, the police can only say no, and with no harm done in asking that question. So again, this is what I mean by there's a few other ways around this, a few other things that we can try as we approach court hearings. If you're waiting for the results to come back, even if you've already been to court and pleaded not guilty, or a court date's fast approaching, there's always options, and there may well be a number of different defence arguments that are open to you. So I wanted to leave the video there. Again, if you have got any questions, then please get in touch, and you'll find our contact details in the description of this video. Thank you.